Today we're meeting with Judge CAROLYN ENGEL TEMIN, the senior judge in the Court of Common Pleas. And Judge Temin, I noticed from your curriculum vitae that you have a lot of experience here and internationally, an author, a member of a number of organizations. And I'm going to get into that a little bit more as we go on, but to begin with, could you give us a little bit about your background?
All right. I was born and raised in Philadelphia, and I'm what they call Penn. I went to Penn undergraduate school and also Penn Law School. Upon my graduation from law school, I stayed home for 3 years because I had a baby in my third year of law school and another one 19 months later, and I stayed home with them for 3 years. In those days, you had to serve a clerkship for 6 months before you could get admitted to the bar. So I actually wasn't admitted to the bar until 1962, even though I graduated law school in 1958.
Yeah.
In those days, there weren't very many women practicing law in Philadelphia or going to Penn Law School. I was the only one in my section. There was one woman in the other section. It was split alphabetically in half. And she became a psychiatrist. So I'm the only woman from my class who actually entered the legal field. And we didn't have any role models, so I didn't know what to do with those 3 years on my resume.
Right.
And it took 20 years till Gloria Steinem or someone said, put down that you spent 3 years taking care of your kids.
It's an important
it's
job.
not, because otherwise people would have thought that I hadn't passed the bar exam the first time around, which I did. I just couldn't get admitted because my father-in-law was my preceptor, which was what the person was called who was in charge of shepherding you through the bar entrance process, and he wouldn't let me work until my kids were in daycare. So now I put it down.
Okay.
1958 to 19, whenever it was, taking care of my children.
Right.
But then I was really worried about being a lawyer because I'd been out of law school as long as I was in law school. Mm-hmm. But I called up the placement office at Penn Law, and they found me a job being an editor at The Practical Lawyer, which is a publication. I think it's still being published by Aliaba. And I went there, and it became clear to everybody there that I was board stiff, and that maybe I should be in court. And they actually told me that. But I didn't think that would ever be possible. I did very well in all criminal law subjects when I was in law school, and I was told it's a shame that you do well in criminal law because no woman can be a criminal lawyer. And the reason given was because they have cuspidors in the courtroom. And probably people looking at this won't know what a cuspidor is, but it's a brass, sort of large brass item that people spit into. In any event, sometimes called a spittoon.
Right, that's right.
So anyway, then something wonderful happened that profoundly, on the national scene, that affected me profoundly, and that was the decision in the Gideon case. Because Gideon said everybody in a criminal case has to have a lawyer. Yeah. And as a result of that, the Defender Association, which up till then had a staff of first 3 and then 5 people, got a grant to add 15 new lawyers because they were going to represent everybody. Up until that time, the Defender Association, which was established by the Bar Association, only represented people who were indigent and in prison. If you could make bail, it was thought you could afford a lawyer. And in those days, that was probably true. And they didn't want to compete with the private bar. That was the reason, because they thought the Bar Association could put them out of business if they started doing that. So they only represented people who were in jail.
I never knew that.
I volunteered with them at my father-in-law's suggestion before I actually got admitted to the bar. And all they would let me do was interview the women prisoners. So every Friday, they would bring the women from the House of Correction, which was then the women's prison, and bring them down and put them in one sort of medium cell up in the sheriff's office. The men were in the back, and the women were all put together in this cell, and they would only let me interview the women. And one day, they needed someone to interview a man, and they didn't have anyone. So they let me do it, and I didn't disappear or dissolve, and
Right.
nothing bad happened.
Right.
So I was hoping maybe that would prove to them that women could do the same job as men, but
Yeah.
it didn't. But when they hired 15 more lawyers and they needed to send us out to preliminary hearings and things they hadn't
Right.
covered before, they couldn't afford to just let me represent women. They didn't have enough women clients.
Okay.
So they let me do the regular work. So, when they got a grant to hire 15 people, they
Yeah.
decided to hire, somebody bumped into me on the street from, who I'd known in law school, and said, you should come for an interview, we're going to hire one woman. This was the token woman thing, and it was
Yes,
quite
of
acceptable
course it
to
was.
say, we're going to hire one woman.
We have to hire.
So I went down and I got interviewed and I got the job, and they let me do everything.
Mm.
And that's how I became the first actual woman to appear in criminal court on a regular basis in
Wow.
Philadelphia. There were 3 other women doing criminal practice, Mary Bell Hammerman and the Duffy sisters.
Only the 3 of you.
Yeah, and the Duffy sisters mainly did misdemeanor cases
Oh.
and things like that. And so I was there every day, and I could cause a sensation just by walking into a courtroom. It was
Don't you do that still?
hopefully not, but it was quite a different era and quite a different time, and there were a lot of things that were in effect then. I mean, someone told me a few months after I was on the staff of the Defender, the person who was responsible for hiring me said, we knew you would be a good choice because you have a happy marriage, so we knew you get along well with men.
Oh, Lord.
And you had to promise that you wouldn't have any more children. The fact that I had my family already.
God, how times have changed.
Yeah. Like people could say things then that you could be indicted for
Yeah.
saying now. And judges also, when I would be in the courtroom.
Oh, I imagine so.
Sometimes, well, first of all, a lot of people in City Hall didn't think that the defenders were real lawyers.
Mm.
But I quickly became the federal defender, and I went to federal court, and I vowed I would never step foot in City Hall ever again.
Little did you know.
And I was able to live with that until I became a DA. But I left the defender after 7 years, and I went to the district attorney's office and did federal habeas corpus for a while
Right.
under our inspector. And then I left there when Lisa Rochette won the bench.
Mhm.
She had been a pro bono lawyer for the ACLU in a case called Imprisoned Citizens Union versus Shap, and it was the first omnibus prisoners' rights case
Oh,
in
okay.
Pennsylvania. And the lead, I can't think now, the lead plaintiff was a very famous murderer who was serving life sentence at Greater Britain. And I took over the case. She asked me if I would take over the case.
Oh, and she's in the bench.
So I left the DA's office and I took over that case, and also I took over a teaching job she had at Villanova Law School.
Uh-huh.
And then I did that for a while, and then I wasn't making enough money, so I called up the first assistant district attorney at that time, was Mike Rappo, and asked him if he had a job for me, and he did. So
Oh,
I
great.
came back to the district attorney's office, and
Okay.
for a while did both appellate work and also homicide trials for 8 years until 1981, when I left to run for the bench.
Yeah. Well, and we're certainly glad that you were elected to the bench.
Yeah, it took a while.
It
I
did.
lost the first election. Both Frederica Massai Jackson,
Right.
who has been a former president judge of the
Right.
court, and myself were the only 2 women on the Democratic ticket. And we were told right off that they were going to bump us off. The
Oh.
board leaders were trying to
Oh.
flex their muscles against the
Yeah,
mayor.
yeah.
And they got together the so-called Black Awards and the
Mhm.
Northeast.
Mhm.
Very weird combination. Got
It
together
is.
and decided to knock us off and put 2 of their own people on, and they succeeded in the primary.
Hmm.
So then 2 years later, I had no intention of ever running again. It was very expensive.
Yeah.
Not as expensive as
As
it is today,
today.
but it was for me quite a lot of money. And I went to a meeting to support women judges called the Committee to Support Women Judges. And somebody came up to me and said, "You're going to run, aren't you?" And I said, "Absolutely not." And they said, "Well, you'd be a fool not to." So I said, "I'll take you to lunch and you'll explain to me why you said that." And he did, and he became my campaign manager. And then I did there was no Democratic slate in that primary. There was no head of the Democratic Party, and they couldn't agree on the slate. So there were 42 individuals running for 12 positions.
Yeah, okay.
And I came in fifth. So I had a lot of support based on the former election. So
right.
everything in your life counts.
Works out some way.
Because people who had seen me thought I was fair, and that also that I behaved well in politics. I didn't badmouth anybody, and I didn't have any sour grapes. I just disappeared.
Well, sometimes that's the best thing to do.
So a lot of people supported me, a lot of board leaders supported me.
It.
And also the other three women. There were four women: TEMIN Myers-Clark, Frederica Messiah Jackson, Sandra Mazer-Moss, and myself. Okay. It was sort of a weird combination: 2 black Catholics and 2 white Jews. And 4 women.
But you were all elected.
We were all elected, and we almost doubled the number of women on the court. Up till that time, there had always been 5 women, not always the same 5, but only 5. Right. And so then 4 of us were elected, and almost doubled the number of women on the court. And now the last time I counted, and it's probably not up to date, there were 43 women out of over 100, about 117 judges.
Yes.
My numbers.
The other courts.
Yeah, and including senior judges and so forth.
Oh.
But it's amazing.
Yeah, it is.
It's really amazing because we almost have 50%. I think if we don't.
I think that's admirable. Because of everything that you've accomplished and that you've done with your life professionally, do you think you could somehow hone in on 1 or 2 or a few of maybe your proudest accomplishments?
Sure.
I would appreciate it.
I would say that my proudest accomplishment happened very early in my career. When I became a criminal lawyer, I noticed that there had been a law on the books since 1932 that was called the Muncie Act. Right. Muncie was the only, at that time, women's penitentiary. And it imposed different sentencing procedures for women than for men. Men could get a minimum and a maximum sentence, and the minimum could be anything up to half the maximum, and the maximum could be anything up to the maximum, from 0 to the maximum.
Yeah.
Right?
Oh, I see.
But women who were convicted of felonies had to be sentenced to the maximum sentence. Now, theoretically, there was a special parole board for Muncie. They didn't get a minimum, just a maximum, a flat sentence. And they had to get the maximum, not anything up to the maximum, but the maximum. And there was a special parole board for Muncie, and theoretically, under the law, they had the power to parole someone at any time. So like the day after they were sentenced. Yeah. But as a practical matter, they didn't do that. As a practical matter, they had a laundry list of minimum sentences that they would make people serve.
Oh, okay.
And also, women were disciplined, women prisoners, for things like sassing a guard. If you go to a men's prison, sassing a guard is generally the way guards are addressed by the prisoners. Yeah. This is just what's done. But the women were put in solitary confinement and denied water. They were not allowed, they didn't have water to flush a toilet or wash. They were denied sanitary items, and they were punished that way. And I decided that I wanted that the law was unconstitutional, and I wanted to have it declared unconstitutional. But I had to look for a case because, as a matter of fact, in Philadelphia, very often the Muncie Act was just disregarded by the judges because they thought it was unfair.
And it seems like
it was illegal to do that, but nobody complained about it. So I finally got a woman who was convicted of robbery, and they gave me her case and said I should do the appeal because I was a woman. I think that's why they gave it to me. And I asked Herman Pollack, who was then the chief defender, whether it would be okay if I raised the issue of the unconstitutionality of the Muncie Act. Right. And he gave me permission to do that. There were no other appealable issues in the case. So the name of the defendant was Jane Daniels. And this may take a while, but you can cut it. What I did, because I think it's interesting, this is lost in the midst of time. Nobody remembers that I did this, or that it even happened, or that it ever existed.
Well, they might know.
But what I did was I raised the issue of the constitutionality of the Muncie Act. And I wrote to Muncie because I had heard that they had this laundry list.
Yeah.
And I asked them I told the superintendent, and I said, I understand you have a list of required minimums. And she said they did, and I asked her to send it to me, and she did. And what I did was I did some research, and I found a law review article by probably the first black woman professor at Yale. Her name was Pauline Murray. She is since deceased. And she wrote an article for the Yale Law Review, and it was called Jane Crow and the Law. And it was all about how discriminatory laws that affected women existed and how they could be attacked with other cases. So I took her law review article.
Yeah.
I don't claim any authorship of this. I took her law review article basically and turned it into a brief. And I attached this laundry list to show that they weren't doing it according to the law anyway. And I raised the issue. And I went to the Superior Court to argue it. And basically what they said was, well, you're arguing that if she was a man, she could have gotten a lower sentence, because what she got was 20 years, the maximum for robbery. And they said, but we don't know what she would have gotten if she was a man, because she's not a man. And they affirmed the sentence.
Lord.
Yeah. So of course I appealed.
How do you get out of that logic?
Yeah. So I appealed to the Supreme Court. And while the case was pending argument before the Supreme Court, I found another woman who was serving time at Muncie. And she had been convicted with a co-defendant who was a man.
Oh, what do you know?
Yes, and she had filed what was then like a habeas corpus petition. And I somehow, I don't know how I got it, but I got it. And I raised the same issue, but this time I said, this is really great, because the man had gotten 3 to 10 years. Here's what they did. She was a prostitute. She would lure people to her room, and while she was with the guy she lured up, her co-conspirator would go through his pockets and take his wallet and his watch and whatever he had. Okay, so someone turned them in, and they got arrested, and the guy got 3 to 10 years, and she got 20 years, and he had a record for other felonies, and she had a record for prostitution. But still, she got 20 years under the Muncie Act, and he got 3 to 10 years. And at the time that I came in contact with her, she had already served 7 years because of disciplinary problems, quote unquote. And he had already been out after 3 years and violated parole and been back in again. All right? So I argued her case in front of Stanley Greenberg, who was a very wonderful judge on this court and a very fair guy. And he said, Mrs. Temin, I agree with you completely, but I have to follow the Superior Court. And I said, good, but when you write your opinion, would you say that, please? And he did. And I was able to appeal her case directly to the Supreme Court because it was similar to her name was Daisy Douglas, and I already had Jane Daniels up there. So I had Douglas and Daniels, and I got them consolidated. And I argued them in front of the Supreme Court. And I think this opinion came down July 7th, 1985, and I won. And they declared the act unconstitutional.
Excellent.
But they didn't say that women had to be sentenced the same as men. And the very next day, they just said that women couldn't be sentenced to the maximum sentence, unless there was a good reason to do that they couldn't be given anything up to the maximum. So the next day, as I recall, the legislature passed the new Muncie Act that said that women would still go to Muncie, but they would get anything up to the maximum, but they wouldn't have a minimum sentence, and they'd still have that same special parole board. So I was disappointed. Well, when I saw that Chief Justice Bell wrote the opinion, I knew right away that it wasn't going to be very liberal. It was going to be on the narrowest possible grounds, and that's what they did. And it took a man. Butler was his name. The case is Commonwealth versus Butler, and I forget the year it was decided. But it took a man, which often happens if you look at the cases involving women's rights. It took a man to get women their full rights. Mr. Butler petitioned the court to be sentenced under the Muncie Act because he said it was more liberal than the because men could only be paroled at the minimum and women could be paroled at any time.
Anytime.
And the court finally said, enough of this. Everybody will be sentenced the same way. So it took a man.
Hallelujah.
It took a man to vindicate women's rights. And if you look at other women's rights cases in other types of areas,
Yeah.
like employment, equality, and so forth, it very often takes a man, and I'm not quite sure why. But I wrote a law review article about it. Of course, this was the year of the Equal Rights Amendment and that push and so forth. And I wrote a law review article called Discriminatory Sentencing of Women, the Argument for the ERA in a Nutshell. And I tried to show why this case, by, you know, what the Supreme Court at that time of the United States was saying was, we don't need the ERA because it's already in the Constitution. Scalia used to say that a lot.
Yeah.
Now he's more or less saying, there's no such thing as women's rights, it's not in the Constitution. I'm not sure what that means. But in any event, I felt that my cases showed that the case-by-case method is very slow and it's not very efficient.
Exactly.
And there were other states that had similar laws, like the Muncie Act, in which the challenges had failed. So I was able to show that this case-by-case method, it does not bring equality.
No,
and that law review article, I think, was published in the American Law Review of fall '71. I don't know, it's in my CV, which I haven't read lately, but it's still true, what's in there.
Yeah.
And it has the whole history of the J.C. Douglas and Jane Daniels cases. And every woman lawyer in law school, every woman law student ought to read it just to see what it was like and how little progress we've made, really, and that we really need an ERA, and every other developing democracy has it in their constitution. I know, because I go around the world
I know that I know.
study other countries' constitutions.
And what about your work abroad? Yeah, I mean, you work for war crimes trials.
Yeah, I was really lucky. I've had a lot of luck in my life, I think. I mean, I got into politics as its slated Democratic candidate because my good friend from law school was the eminent squeeze to Mayor Green, and I didn't ever have to work in politics. I don't know whether I should say that, but most judges have paid their dues. And I only paid my dues by running and losing, but apparently it was enough.
That's enough, I think.
But when I was about to become technically having to retire here, mandatory retirement age at 70, and during my 69th year, in August or July of that year, the National Association of Women Judges, of which I was at that time the president, got a letter from the Office of the High Representative, who is the UN appointee to be the dictator of Bosnia and Herzegovina, basically a dictator.
Yes,
he has awesome powers. He can remove elected officials, things like that. So his office sent a letter around, not just to us, but to a lot of organizations, because a very prominent lawyer, Jerry Shestak, also sent me a copy of the letter which he had sent to the ABA, you know. And it said, do you have anyone? We need some Americans for the court. And the qualifications were 10 years experience trying complex criminal cases, being fluent in written and spoken English, and getting along well with others. So I lied a little bit. Getting along well with others. But some people would say that I did. But anyway, I circulated the letter to all the members of the NAWJ, and nobody jumped up and responded, which is not surprising given that you would have to retire to do this. American judges, other than those in Minnesota, are not given sabbaticals. In Minnesota, after 10 years, you can take a 1-year sabbatical without pay, without pension contributions, all that. And there had been 2 judges, male judges from Minnesota, who had been serving from 2003 to 2004, but they only could leave for a year, so they had to go.
Oh, I see. So their time was up.
And nobody responded, so I decided, all right, I offered it to everybody. They didn't want it. I'll send my CV in, and I immediately got a phone call saying, you know, we'd be honored to have you. And I didn't understand why they were saying that till I got to Boston and found out who else was there. But
tough job.
Well, it turned out that countries who felt like it sent people, but they didn't necessarily send qualified people. And a lot of the, not a lot, but a number of the judges were from civil law countries, and Bosnia had just become a common law country. So they were sending civil law judges who were saying, guilty pleas, guilty pleas. What's a guilty plea? I'm not taking guilty pleas. That's giving away something. No. And I had to basically conduct Guilty Pleas 101 to teach them about guilty pleas and about the procedure and the whole 9 yards. But anyway, they took me, and it kind of coincided with my retirement anyway. So I retired in September instead of December because they wanted me to come right away.
Well, it worked out well.
And so I was a judge on the Court of Bosnia and Herzegovina, which is the only statewide institution in the country. You have no idea what that means unless you know the history of Bosnia and Herzegovina. It's a very divided country that's divided ethnically and geographically and politically along religious lines.
You're right. It couldn't be any more divided.
No, the Bosniaks are Muslim, the Croats are Catholic, and the Serbs, Bosnian Serbs, are Eastern Orthodox. And they live in different parts of the country. There's a whole part of the country called the Republika Srpska, which is not the Republic of Serbia. It's just a part of Bosnia called the RS, and it has different laws. The laws are all the same, by the way, because I did a bench book, criminal and civil,
I
with
saw
Bosnia, and so I'm familiar with all their laws and what we had to do. The laws are the same, but they're numbered differently. So we had to put 2 numbers for each section that we were quoting, but they were really the same. But the state court that I was in was the only state institution in the country, statewide. It was unbelievable. Yeah. And when I went there, it was only in its 2nd year, and it was very primitive, and it was in a way a very, very difficult experience, but in a way very rewarding because, when I came on this court, it had already been in existence, the oldest and most court in the country for over 200 years. And to go and be on a court that was only 2 years old, and to be in a court that still wasn't in good quarters. I mean, everything was wrong. The physical plant was wrong.
It's like giving birth to a legal system.
Yeah, the physical plant was wrong. They had no idea about court scheduling. Judges from civil countries never heard of case management. They just schedule a hearing in a case, and if they don't finish the case, they have a meeting and schedule another hearing, and they think that's normal.
Okay.
So when you bring up the idea that we should have a schedule, they can't deal with it. But so they appointed me to be in charge of it, so I made such a fuss about it.
You have a schedule, and you have to keep to the schedule.
Yes, we had one courtroom, 3 days a week for cases involving international judges. That was it. So, and we had 6 cases, and they were long. The major case that I tried took 11 months.
Wow.
Well, war crimes and complex economic crimes, like someone embezzling €2.5 million from the country, who was defense minister at the time and a former president of the country. That was the defendant, and so it takes a lot of time. And the lawyers, because of the way the court schedule cases, the lawyers' schedules are all Swiss cheese too.
So okay.
When you try to, but I made an Excel chart and gave everyone a different color, and we met once a week and worked out 2-week schedules. So
it worked.
Yeah, it did actually.
Good.
But they had no court administration and no infrastructure and no way. The Bosnian judges did not speak English, or if they did, they weren't letting on.
Yeah.
As we might be a little inhibited with another language. So, and they put the Bosnian judges. It was a former barracks, so it had 2 long buildings connected by a hallway. And they put the Bosnian judges in one end of the building and the international judges in the other end. And so if you just wanted to say good morning to a colleague, you had to take an interpreter. I mean, well, you could say good morning, we all know that. But I actually hired a private teacher and learned to get along in what's now called Bosnian, Serbian, Croatian.
Yeah, I was wondering about that. There must have been difficulties.
Well, it's a very difficult language, and it's not like any other language that most of us Americans get to learn. I'm fluent in French, but it's not a Romance language. And I speak Hebrew and Yiddish and therefore German, but it's not like any of them either. It's a little bit like Russian, a little bit, but not totally. And it's got Latin, and when you get to know it, you can recognize the roots. And anyone who marched through, the Turks,
left some language.
The Romans, left some language behind. So it's a combination. But it was. I can't. I mean, I could spend hours and hours. I have given a PBI course on comparative criminal law, which is very interesting because in many ways the emerging democracies have laws that appear, at least on the surface, to be fairer than ours. Like in Bosnia, the defendant gets to pick. If the defendant is indigent, they get to pick their lawyer from a list proposed by the Minister of Justice. And they don't get just court-appointed counsel, they get their choice of court-appointed counsel. And so very often in the beginning, they play this game where they get a private lawyer for the preliminary hearing part, and then they come in and say they're indigent, and then they get to pick their private lawyer for free.
Right.
And I hope they're doing something to stop that practice, but maybe not, they may not care. And they also get paid very well, much better than the lawyers.
Well, okay, I know that's a sore spot in a lot of courts, including this one. I know that there's so much that we could get into with you, Judge Temin, but to try to just keep it, I guess, to a bare minimum, I wondered also if you had any advice for somebody just starting out to be a judge. I mean, you've taught in a lot of different settings and helped judges.
That's what I do internationally now.
I know you're a champion of judicial education.
I train judges in case management, and I'm doing a course now in Georgia, the Republic of, not the state, on communicating from the bench. And it's interesting that they thought it was necessary to have that. We need that here too. They sent some interns into the courts to observe the judges, and they wrote a report, and everything that they wrote in their report I've seen here as well.
Okay.
I think we need it, but
right.
I would say, first of all, know the law cold. Just know it. Be able to rule on evidence and other things from the bench efficiently, because having a sidebar conference about everything is really a waste of time. The other thing is to manage your docket efficiently, to conduct good pretrial conferences, and learn, how to judge how long a case will take, and learn what factors you have to consider. I wrote an article recently published by the ABA Journal, the Judges Journal, on just that, on using data that's available in the court to case weight, to decide how long a case will be and how complex it will be. And judges can do it on their own if their court administration isn't doing it. And also to be a judge. Don't be yourself. And that may sound funny, but don't be the person you are with your friends socially when you're on the bench. On the bench, you have to be dignified. On the bench, you have to be formal. On the bench, you don't make jokes. Everybody will laugh at your jokes. You're the judge. Everybody will stay around while you're talking because you're the judge. You soon realize that lawyers are sitting there listening to you tell war stories. But judges don't often realize that. They don't realize that they have a judge persona. It's not that they're not themselves. They're themselves as a judge. But they have to have their own style. Every judge has to have his or her own style. But it has to be dignified and formal. A lawyer should expect that all they have to be is on time and prepared. That they don't have to curry favor with you by X, Y, or Z.
Excellent.
And that you will know the law and decide and follow the law. That you will not make up some cockamamie result just because you think it's a better result. That if you think the law is not fair, that you will either find a way to work within it in a way that's acceptable to you, or you will grasp the knot in your stomach, swallow the bitter pill, and pronounce the sentence like the mandatory sentence that you don't think is required, but that the law requires, and just do it without comment and without inflection.
You don't need an excuse.
No, and just do things, and for God's sake, don't get in an argument with a lawyer in court in a case over a legal point. You're the judge. Make up your mind and decide. Don't hold an auction. It's not, you're not a lawyer. The lawyers argue with each other. You make the decisions. And it's a totally different role from being a lawyer. Writing an opinion is totally different than writing a brief. And learn to write well. I think that judges should write well. It's important. As someone just wrote an article in the New Republic about Elena Kagan's dissents and how wonderfully they're written. And contrasted it with some of the other judges on this justices on the Supreme Court. But in any event, it's important, I think, to write well.
I
And
agree.
also be a role model and be a mentor. Invite younger lawyers, law students, if you have an opportunity to have legal interns in the summer, even though it can be more work, take them.
Okay.
You know, help, especially if you're a woman judge, help bring young lawyers along, and especially women, and help women. Women have special problems still being litigators. Some of
Yeah.
them have these high squeaky voices, and some of them dress inappropriately, and you need to be a mentor to them.
Yeah.
And so you have to be a role model. And you have to be aware that you're always a judge, that you're not just a judge in the courtroom, that you are a judge in the courthouse. I've had people say to me, well, you could wear jeans because you were a road
yeah.
and nobody sees you. And I said, of course they see me. They see me when I walk through the lobby. They see
Yeah.
me in the Reading Terminal Market.
Yeah.
They may see me in a restaurant. They may see me on the weekend. And I remember Judge Katz once told me that he was criticized by an older judge, and this is a long time ago, like in the 80s, for going to a baseball park wearing a baseball jacket and a Phillies hat. I think that's going too far. You can wear a baseball jacket and a Phillies hat as long as you wear it. As long as you don't shout things that are inappropriate for a judge to say. But I think you have to remember that you're always a judge, and that it
Okay.
affects your family, it affects your social life, it affects your activities. There are activities you can't indulge in no matter how good the cause is. You can't
Yeah.
go down to the gym and pedal for the March of Dimes.
Mhm.
You can't do that. You can give money, you can vote. That's about it. And it affects your family and the way your family has to behave, and they have to know that.
Okay.
Also,
Yeah.
they don't have to be goody two-shoes, but they have to know that they can't talk about your work, that you can't talk about your work to them.
To them,
There's a
right,
reason.
right.
You know, there are a lot of things that I teach judges in other countries that I have not been asked to teach here, but that I think judges need to know about being a judge.
I think it all sounds like great advice. I appreciate
Thank
it.
you.
Is there anything else you'd like to share with us before we?
Oh, I just wanted you to know that I feel incredibly lucky that I have the best job in the world, and that everyone on the court should feel that way.
Wow.
And I feel that way. I feel in the people I've met, yourself,
I thought I was doing pretty
and
well.
other
yeah.
people, and the connections I've made, and the sheer luck that you have by just being in the right place at the right time, and use it. Of course, you have to be ready, you know,
Yeah,
to
right.
seize the opportunity.
Listen for the
So
knock.
carpe diem, you know.
Right.
And really, that's about it.
Thank you again, Judge CAROLYN ENGEL. Thanks very much.
You're welcome.